Hi everyone, my name is Vamshi Krishna. I'm assistant professor in St. Martin's Engineering College, Department of FME. So today my topic is relating to alternate dispute resolution, ADR. So coming to alternate dispute resolution, I am going to first explain about what are the methods of alternate dispute resolution and how the name alternate dispute resolution came. So coming to this process, I am going to explain in the methods of alternate dispute resolution and the PPT and the video. So coming to alternate dispute resolution, first I am going to tell how the alternate dispute resolution started. The term alternate dispute resolution. The term alternate dispute resolution came when there is more litigation on courts and when there is more disadvantages compared to advantages over the courts, the dispute process has been started. So coming to alternate dispute resolution, it is a one type of dispute resolution method or technique that will be going to helpful to solve the disputes between the two people. So mostly alternate dispute resolution functions are to solve the disputes between the two people, and it is a very cheap and many advantages are there over the disputes that can be solved quickly. So mainly the alternate dispute resolution is a technique that is used to solve the disputes between two people. So commonly we all know what is meant by dispute. See, dispute is nothing but it is a problem between the two people, and when they are in the contract or when they are in the one property issue or any litigation like that. So coming to alternate dispute resolution, as I said, there are in general five methods. So the general five methods of alternate dispute resolutions are: first is the conciliation, second is the mediation, third is the important one, that is the arbitration, and fourth is the negotiation. And in this fourth, you can also add negotiation and collaborative law. And the last but one not the least is the adjudication. So coming to the alternate dispute process, as I said, first was the conciliation. Coming to conciliation, it is a one type of the alternate dispute resolution in which two parties are involved in front of the conciliator. So coming to conciliation, it is a technique alternate dispute resolution where two parties are involved in front of the conciliator, and they will tell about their problems, and the conciliator here is a skilled person, and he will generally tell about the how the disputes are happened, and he will just listen to the arguments. So coming to this method, it is very cheap and it is generally very easy process. So just the conciliator is a voluntary court chosen person or the parties involved person. So the parties are first come to the conciliator, and then they will discuss about the method. They will tell about how the process has started. So the conciliation will be sessions of the face to face or telephonic, and these are the very important process, and that will be continue the like sessions to sessions, and the conciliation is a very important process. Okay, coming to the second method is the mediation. So the here the word the mediation is, we all know, like it is the same the technique like the alternate dispute resolution. So here the word mediation. So the word, as the word suggests mediation, we will mostly concentrate on the term here. Here the word term is the mediator. So here also the same, the two parties are involved, and they will be in the dispute, and here the person involved is known as the mediator. So here also the mediator will have been face to face or telephonic conversations, and he will listen to them, and he will not give any binding decision. So whereas in these two techniques, if you compare conciliation and mediation, it is just like the same, but you have to be more advisable based on the decisions. Okay, like mostly conciliation and mediation, the techniques are same, just like here the word conciliation and here the word mediation. So the face to face and telephonic, these are all the same. Just here the mediation or conciliator just listens to the argument, and he will not give any decision. So remember, here and here he will not give any decision, he just listens to the argument. Okay, and coming to the next, that is the important one, that is the arbitration. So arbitration is an international process and a domestic process. Coming to arbitration, so the here the person is called the arbiter. Okay. So once the dispute is done, and that is in between the two parties, the third person or the third party is involved is known as the arbiter. So who is the arbiter? Arbiter is a person, or he is a voluntary or court approved person. He will be there at the time of the dispute, and he will be listening to the disputes, and whenever the any disputes are there relating to court or land settlement or any type of patent, copyrights, any issues, the arbiter along with the two parties and the disputes are continuing. So in the arbitration, mainly the person is known as the arbiter, and here is very crucial, like arbiter gives the decision for the disputes known as the arbitration award or the award. Okay, remember the dispute, the which he solved or which he is giving, that is called the arbiter award. Okay, so remember arbitration is generally of two types, that is the international arbitration and the domestic arbitration. So coming to international arbitration, mainly it is solve the disputes of the foreign and other countries level. So that will be international level, and coming to domestic level, that is in the India level. So generally international arbitration, they require many usages and many outcomes are required, whereas in the domestic it is just for the Indian case, and that will not require any more permissions. So remember, in the domestic again there are three types. Coming to the domestic, first is the fast track arbitration, next is the institutional arbitration, next is the ad hoc arbitration. So in domestic, these are the three types of arbitration. So first is the fast track arbitration, second is the institutional, and third is the ad hoc arbitration. So fast track arbitration is the process, is nothing but the arbitration process, like the dispute process which is there, that is being solved within less days of time. So that is called as the fast track arbitration. So whatever may be the situation, the outcome or the result or the award which will be very fastly soon. Okay. And next is the institutional arbitration. It is according to the institutes and the disputes which will be done over there. And this is also termed as the slow type of arbitration, because it will be gathering more required of proofs or more required of data. and that will be received and tell by the arbiter. Coming to the ad hoc arbitration, this is nothing but the arbitration dispute resolution method that will tell about like most important cases, or that involved with the highly reputed cases, or that is involved with the highly reputed judges. So coming to this, it is about the arbitration process. So finally what we will going to see is a very quick response, very quick output, and very quick judgment, and the final judgment is received here is called the arbiter award. Okay, next is the final last process is the final last process is the adjudication. So adjudication is the latest ADR process that is called the in this the adjudicator or the person is known as the judge. He is appointed from the court, and he is listens to the disputes same like the court, and he will give the judgment. So here the process is the person is known as the adjudicator. And coming to this adjudication, the very most important technique is like adjudicator gives the response or gives the judgment within 28 days. That is very fast judgment. Okay, so remember, adjudication is a process that is we are going to get output or the response or the judgment within 28 days. That is the major benefit of adjudication. So coming to this, I am once going to explain about in the PPT. So as I said, alternate dispute resolution. So it is a mechanism of dispute resolution. It is non-advisorable, that is not litigation of courts, and it can be instrumental and it can be judgmental. Okay, coming to the ADR techniques, as I said, it is firstly it was 5 types like the conciliation, negotiation, mediation, collaborative law, and arbitration. So finally, what happened in the later days, like this negotiation and collaborative law are combined into the one type, that is the adjudication. So as I said, conciliation, neutral third party; negotiation traditionally occurs between the two parties; and mediation, collaborative law; and the arbitration. As I said, the dispute process is is between the two people, and it remains same in the conciliation and mediation, and difference in the arbitration. Okay. So as I said, conciliation is nothing but generally known as the conciliator helps the parties involved to reach per issues, and it is generally of face to face or telephonic. Here the person is known as the conciliator, and a conciliator, as seen, he is stopping the issues between the two people or solving the disputes between the two people. So generally he is a third party and he listens to the disputes, and he is known as the conciliator, and generally the conversations between two people will be telephonic or face to face. Coming to mediation, it is an ADR process. It is an ADR process. It is an ADR process. It is also same like the conciliation, and it is here the person is known as the mediator, and it only assists in the problem solving. And here also same, the mediation period is always, so mediation period is always taking place between face to face. So mediation period is always taking place face to face between the parties involved, one or more. Then the mediator is present. So here also same, a conciliator and mediator can also be involuntary, voluntary, court approved, or mentioned in the contract. So coming to the next process, arbitration. So it is a ADR process which is very important. So here the person appointed is known as the arbiter, and the arguments here listened by the arbiter. And here main important is nothing but arbiter will listen to the disputes, and the process involved is in between the two parties. So arbiter here is a more formal and structured contract, and he listens to the disputes, and the arbiter gives an award known as the arbiter award. And coming to see, as you can see here, there is a problem between two people, and he is the arbiter, and he gives the dispute in the form of arbitral award known as the arbitral award. And like he gives a binding decision between the two people. So as you can see that it is a arbitration meaning is that is not more and less than litigation, and the more advantages of the arbitration are it is a fast and dispute process, it is a secure process, and it will give the binding decision, and it will be very safe and secure, and it is morely less burden to the courts and not more than the litigation. Coming to advantages, see advantages of arbitration dispute resolution techniques, like it is takes less time to reach a final decision, and it is fast, and it is very cheap, and it will it will be very less burden on the courts. And you can see as increased compliance with agreed solutions, and it is the mostly advantage over solving disputes rather choosing than courts. Coming to the disadvantages, it is used as a stalling tactic. What do you mean by stalling tactic? Like it can be sometimes mislead, like the proofs which we don't submit at the time, that can be misleading. And one more strong disadvantage is this, like whatever you use the money in this alternate dispute resolution, that again cannot be came back. Like you are very carefully you choose the investment in this, and because the proofs which you are providing that are sometimes not reachable, but if you are unable to provide at the time, that cannot be recoverable again. So that is one of the major disadvantage using the alternate dispute resolution. And it does not produce legal proceedings. Exclusion of proceedings over weekends final agreement. Okay. So here the main other drawback is parties have limited bargaining power. So the parties here cannot have any bargaining power, and see that is one of the major disadvantage, because see generally we have to bargain, and we have to generally tell about the how the disputes are need to be solved. So like these are the disadvantages. And coming to adjudication, as I said, adjudication is the latest type of ADR process. Like here the person involved is known as the adjudicator, and he tells about the disputes between the two people, and that is majorly he listens to them as a judge. Okay. And then the judge, as in the same like the way of the court, the proceedings are going on, and there will be hearings in the 1 2 3 way, and that will be postponed, and finally the adjudicator tells the judgment within 28 days. That is the major advantage here. Like so anywhere the judgment will be coming in the three types of ADR process, but the in the adjudication the output will be in the 28 days. That is the faster response known as the judgment. Okay. So it is also more formal type of process, and it is a contract of the parties provides the option of an adjudicator, and that should be chosen by the professional bodies. So coming to these are the four types of ADR process. Once again I am telling the types of ADR process are conciliation, mediation, arbitration and adjudication. So here are the major important topics we discussed in the alternate dispute resolution, and advantages and disadvantages. So majorly we remember conciliation and mediation are the process which involved about the dispute resolution techniques based on the conciliator and mediator, and these are mostly often face to face and telephonic, whereas the arbitration it is a important decision of the arbitration dispute resolution, and the finally is known as the award. And last not but the least, I discussed about adjudication. Adjudication is a faster process of judgment, and it we can get output or judgment within 28 days. So coming to the as I said, you might be sometimes confused, so I have given clarity difference between the arbitration, mediation and conciliation. So you can see arbitration is a dispute settlement process which involves impartial third party. Conciliation and mediation also involves about the third party but does not give any binding decisions, and it is regulated by the Arbitration and Conciliation Act of 96, and it is mediation is on the Code of Civil Procedure 1908, and prior agreement is required in the arbitration and not required in the mediation and conciliation, and valuable for existing and future disputes. See, this is one of the major advantage of choosing arbitration over conciliation and mediation, because the disputes, not only existing but also future disputes, are solved in the arbitration. And example is, see, damage in the case of breach of contract, matters of the right to the office time, like these are some of the examples. And in the conciliation and mediation, it is about resolving disputes and commercial transactions, patents or trademarks. Okay, so you see, like these are the common, mostly seen differences between arbitration, mediation and conciliation. So remember, compared to these three, you can easily choose arbitration, because arbitration, it is the most important and easy technique in the ADR process, as it tells about the binding decision. And arbitration, as I said, it is a settlement process between the two, and it will gives a valid and input output. Okay, and whereas in the conciliation and mediation, you can choose, but you will just, the conciliator listens to the argument but cannot give any binding decision. So enforcement is nothing but arbitration has the power to enforce this decision. So what do you mean by enforcement? Like if any decisions are there between the two parties, that will be enforced. Like enforced by law, we will hear the word enforced by law. What do you mean by that? Like the law is involved here. Okay. Coming to the conciliator and the mediation, the conciliator does not have the power to enforce his decision, or else the mediator has the does not have the power to enforce their decision. So arbiter has the power to enforce his decision and give the output, that is the arbitral award. Okay, and it is regulated by the Arbitration and Conciliation Act. So coming to arbitration, it is based on the Arbiter and Conciliation Act of 1996, whereas the conciliation and mediation, it is also saying like conciliation is required of arbitration and the Conciliation Act of 96, and the mediation, it does not involve any act, but it requires Code of Civil Procedure 1908. So it is very old process. Okay, remember, mediation is a very old process, and we have seen from the early 90s. Okay, like it is followed Code of Civil Procedure 1908, and the prior agreement is required. So see, whenever we are going to the dispute, and when we are choosing arbitration, first we have to give the prior agreement. So that is what required here. And while choosing the conciliation and mediation, prior agreement is not required. And it is available for existing and future disputes. And finally, here it is a conciliation and mediation available for only existing disputes. So remember, the present and the future disputes, if you want that to be solved, you have to go for the arbitration. And if you are only having present disputes or only past disputes, then you can choose conciliation and mediation. Okay, and it is as I said, examples are very important. So see here, damages in the case of breach of contract or matters of the right to the office, time break claims. So like these are the standard examples of arbitration. And if you see the standard examples of mediation and conciliation, it is nothing but the resolving disputes between contractors and subcontractors. So this is one type of example for the conciliation. And if you see the example for the mediation, here the commercial in transactions, patents, trademarks, license, ventures and R&D contracts. So if you see patents, it is nothing but it is a one copyright or patent like under one name, like, and that if any cases happen in that, we can go to the mediation and that will be solved by the mediator. So what do you mean by copyright? It is nothing but one copyright that will be under our name, and if any disputes happen in the copyrights, again we can go to the mediator. So like these any disturbances or any disputes in the venture capitals or in the land R&D contracts, music and other film contracts. So any disputes are there relating to these matters, we can go to the mediation. So, as I said, the important type of arbitration ADR process is nothing but the ADR arbitration. So, remember, arbitration is no more than the litigation, and these parts can apply where the place of arbitration in India. Okay, it shall not affect any law. And remember, arbitration has used the acts like subsection 1 of section 40, section 41 and section 43 that shall apply to any every arbitration and attachment for the time being. So remember, the important types of ADRs we discussed. So remember the types of ADRs we discussed. So important types are here conciliation, mediation, third not but the important is the arbitration, and the last is the adjudication. So firstly, I told about two important topics. Other than this, there are collaborative law and negotiation. So once I want to tell about this, collaborative law is nothing but it is the law that is mainly used before the adjudication. So collaborative law tells about how to use the dispute solving methods between the two people, and mainly that involves the negotiation process, and so that is finally added into the adjudication. Coming to negotiation, we all know it is a very old process. Negotiation is nothing but it tells about the dispute solving methods, and it is mainly involves about the bargaining. Okay, so negotiation involves how to solve the dispute using the bargaining technique. So combinedly these are very creating burden on the courts, so these are combinedly used in the form of adjudication. So these collaborative law and negotiation in the later process combined and used in the form of adjudication. So alternate dispute resolutions are majorly of four types, that is the conciliation, mediation, arbitration and adjudication. So these are the four types of the alternate dispute resolution process. So remember, alternate dispute resolution means it is nothing but it tells about the dispute resolution process, and it mainly reduce the burden of the courts. And every time remember, we cannot go to court for the small type of dispute, so we have to choose any types of alternate dispute resolution. So finally, I am going to tell about the one simple video. So here you can see these are the arbitration dispute techniques, and here you can see two people are discussing, and there comes the one arbiter, like he is the person who's telling about the dispute technique. So if any contract is break, then he can come in the middle and tell about them, like what is the problem, how it is being solved, and see, like he is giving the judgment, and he is across all types. And see, as I discussed, there are two types, domestic and international. And in these litigation, alternate dispute resolution, like arbitration, mediation, and conciliate. So here any type of disputes, he will be there, and he will be coming, and he will be solving. Mediation and conciliation are the basic important techniques preferred to arbitration. So anywhere he is the person, if in the mediator, he is the conciliator, and he is also the arbiter. Okay, so these are any types of disputes relating to construction, intellectual property, purchase and sale, and other than the disputes, anything that will be considered. So he will be creating less burden on the courts, and that will be solved and the slow process. So these are the important types of alternate dispute resolution techniques. Thank you, everyone.